Okay, it doesn't look like anyone's in the as of yet, so maybe that this is the only case that we have ready to go. Ms. Helen, would you give him a call and let him know that we're ready?
Understood, Judge. Hold on one second.
And this is a negotiated plea, Your Honor.
Thank you, Ms. Kenny. Good morning. Good morning, ma'am. Are you here for?
Hey, Judge, Mr. McLean is actually walking into G33, or at least he's on his way, so you'll see him shortly. But again, before he walks in, we can take any position from 9 to 18.
Okay, thank you, Ms. Helen. That looks like it's the only position that we have at the present time.
Understood.
Are you, do you know who's representing the bench warrant today?
That'll be Mr. McLean, Judge. He's already spoken to that person, and it'll be Mike McLean today.
What's the first name, Marie? Martio.
Okay, thank you. All right, well, I guess we'll be in recess until someone's ready to go. Okay, let's see, Mr. McLean has joined us in the courtroom.
I'm sorry.
Speaking to people, letting them know you're here with us. And, yes, good morning, Mr. Edwards. I'm Judge Eric Morrow. This is the civil law purpose calendar that we're conducting by video to help prevent the spread of the virus. Did we have your case heard by video? You hear me, Mr. Edwards?
What you say, son?
I said, we're doing this by video. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? You swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
All right, you put your hand down. Thank you. Ms. King?
Yes, Your Honor, the negotiated terms are 12 months to serve, 34 days, credit for time served, 17 days with the balance probated, a FVIP course, no further contact, a stay away, and no drugs, alcohol, or weapons. Everything just closed. One moment. The stay away is from 1611 Harvard Avenue, apartment 19. And the no further contact is with Shanetta Reed, SHANNETTA, last name REID.
Let me ask my client if I might, Your Honor. Mr. Edwards, who is at the Harvard Avenue address now? Can you hear me?
I'm sorry.
Who's at the Harvard Avenue address?
You said who's at the Harvard Avenue address?
Who is there these days? Who's there now?
My sister, that's my sister's house. My mom, she don't stay at the Harvard Avenue. She actually resided at a hotel right now.
Okay. So I think the stay away might not.
One moment, Your Honor, let me see if we have any updated victim contact regarding where she's residing. One quick second. Your Attorney McLean is correct. We had contact with her quite some time ago, and she stated she will not be living there.
Okay, so no stay away.
That's correct, Your Honor.
Thank you. Anything further?
Nothing, Your Honor.
All right,
Nothing from the state.
thank you. Mr. Edwards, it's my understanding that in case 22 CR 006638J, you wish to plead guilty to battery family violence, is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
I'm sorry. I couldn't hear you.
You've been represented by Mr. McLean. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
I understand.
Has anybody forced or coerced you to plead guilty?
No, sir.
All right, I'll accept the plea as negotiated, Mr. Edwards. I am going to waive the probation fees for you while you're on probation to help you stay on your feet, okay?
I'm sorry. Could you repeat the last part again?
Yes, I'm gonna waive the probation fees while you're on probation to help you stay on your feet, okay?
Okay.
All right, good luck to you, sir.
Thank you.
Thank you.
Your Honor.
Yes, good morning, Mr. Wright.
Good morning. How you doing?
Doing well, thank you.
Good. Position number 11, Tamaya Jacobs. We're trying to figure out, her attorney is on the line as well. We're trying to figure out if South Annex is on. Is there any way that her attorney could speak with her, a breakout room or something?
I don't see the South Annex, do you, right now? So, Ms. Lewis.
No,
would you-
the South Annex has not logged on yet. I will give them a call to see what their status is.
Okay, I'd appreciate it. Thank you.
Thank you.
Oh, Your Honor,
Yes, Mr. Wright.
I noticed this setup is like it was the other week. I noticed there's something wrong with it. The camera is facing this way, although my microphone's working fine and I can watch the large display. If I turn this physically around 180 degrees, I'll be on camera. If you don't mind,
Whatever you wanna do, Mr.
I'll
Wright.
jump up and do that.
Make yourself comfortable.
I did this a couple of weeks back when I was in person, so
Okay,
I know the trick. There,
okay.
thank you.
Who do we have in courtroom two?
Morning, Judge. This is going to be position number 8, Mr. Finnick.
Good morning. And this is also going to be a negotiated plea, Mr. McLean.
It is.
Great. Good morning, Mr. Finnick. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can put your hand down, Mr. Finnick. Thank you. Ms. King?
Yes, Your Honor, this will be a global resolution along with case number 22CR001-578J, which is a simple battery charge involving the same victim. The terms are as follows: 12 months to serve, 122 days, credit for time served, 61 days with the balance probated, a FVIP course, no further contact and no drugs, alcohol, or weapons. The no further contact is with Crystal Glenn, CRYSTAL, last name GLENN.
Excuse me, Judge. I thought Mr. Finnick had a conflict attorney supposed to be Ms. McLeod.
That was my understanding.
Yeah, because you
And
represented him on October the 5th on
I
the
did,
FDA calendar.
yes.
Oh, well, we were operating in ignorance, so that's fine. He could go forward with the conflict attorney.
Okay. Good morning, Ms. McLeod.
Good morning, Your Honor.
All right, so do you need anything further before we, on the court or Mr. Finnick before we go forward?
No, Your Honor, because I understand that he has already heard the terms of the plea and wants to accept it. I have not actually spoken to him. I was waiting to speak with him. I had contacted the jail.
Okay.
But I do have his plea paperwork and everything already.
Okay, so we're good to go.
Yes, Your Honor.
Okay, very good. Thank you. Ms. King?
Yes, would you like me to restate everything again?
Anything further?
Oh, no, nothing further, Your Honor.
Okay, Ms. McLeod?
Yes, Your Honor. We stipulate to the statements made by the prosecution with respect to what the cases are, and we do understand that it's going to be a global resolution, the terms of which are time served on the other stipulations that the prosecutor stated, Your Honor.
Mr. Finnick, it's my understanding that in case 22CR006681J, you wish to plead guilty to battery, family violence, and in case 22CR001578J, you wish to plead guilty to simple battery. Is that correct?
Right.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
Represented by counsel, are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the guilty pleas as negotiated. Mr. Finnick, let's see. I am going to waive your probation fees for you while you're on probation to help you stay on your feet, okay?
Thank you, sir.
All right, good luck to you, Mr. Finnick.
Thank you.
Thank you, Your Honor.
You're welcome.
Your Honor, I will be sending the plea paperwork shortly. After that, may I be excused? Because this is the only matter I have on the calendar.
Yes, Mr. Cloud. You have a good rest of your day.
Thank you, Your Honor.
Excuse me, Judge, I have an announcement.
13,
on South
Mr.
Annex,
Mosley.
please. I'm sorry. I'm sorry. I just got that off the phone with Officer Milton. She said that they will be on at 9:30. So if the private attorney, Ms. Calloway, if she can, I'll put the number in the chat where you can call her directly. But she will have her in the South Annex area at 9:30.
Thank you, Ms. Lewis.
You're welcome.
I'm sorry, Court, to tell me again who we have?
This is position 13, Mr. Mosley.
And this is going to be a arraignment and a gift and arraignment. Is that right?
That's correct, Judge.
Good morning, Mr. Mosley. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. We really have the case heard by video.
Yes.
Can you raise your right hand for me? Do you swear to affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Good.
Put your hands down. Thank you, sir. Mr. Mosley, you've been charged in case 22 CR 0067642 with driving under the influence of alcohol, less safe, reckless driving, failure to maintain lane or improper lane change, distracted driving, failure to exercise due care, and vehicle to drive on the right side of the roadway. Each of these charges carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Wait for a reading of the accusation, Ms. Helen.
I do, Judge.
We plead to these charges, Mr. Mosley, guilty or not guilty.
Not good.
To record your not guilty plea, your case will be returned to the division judge and we get notification of your next hearing. Good luck to you, Mr. Mosley.
Next, we have number 12, Mr. Manning.
It's gonna be a non-negotiated plea.
Yes, Judge, and because of the nature of the charge, I was wondering if we could have a breakout session if we were going to sound the charges, but I prefer they be in a breakout session, Judge.
Correct me if I'm wrong. I know that the solicitor's office has been objecting to having anything done in a breakout session. So until you all resolve that issue, we're not going to have breakout sessions, Ms. Helen. As far as I'm concerned, I don't know what the other judges are doing, but it's my understanding that the solicitor's office wants these all to be on the record. Is that correct?
That is correct, Your Honor. Thank you.
Understood, Judge.
Mr. McLean,
Yes, Your Honor.
would you do me a favor? We have a very short calendar today. Your 11 o'clock bench warrant DV is set for 11 o'clock. If he wants to get on earlier so that we can take him earlier, we're happy to do that.
Okay.
I don't know if you have his contact information that you could.
I believe I do. I'll have to, I'll look at my phone and see if I marked his name as opposed to figuring out his phone number from how late at what hour I spoke to him last night. Your Honor, in that case, I do need to talk with the state ahead of time to see if the matter is resolved. It may not require a hearing if the state is in agreement, but I do need to speak to them.
Okay. Thank you, Mr. McLean. So if you'll try to do that when you get a moment, I'd appreciate it.
Yes.
Good morning, Mr. Manning. I'm Judge Eric Morrow. This is the state all-purpose calendar. Can you hear me, sir?
Yes, Lord.
We're conducting this calendar today by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, Lord.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Lord.
Okay, you can put your hand down. Thank you, sir. Ms. Salette?
Excuse me, yes, Your Honor. The state's recommendation for the sexual battery charge is 12 months to serve. For the public indecency, 12 months probation to run consecutive, a psychosexual evaluation and treatment, and stay away from all MARTA stations. On September 12th, 2022, Detective Hunter with the MARTA Police Department reviewed surveillance footage from the Civic Center MARTA station at 435 West Peachtree Street. And he was able to observe the defendant lick his hand and lean towards the victim, Ashley Gresham, and grabbed her legs and rubbed her vagina on top of her clothes. He also observed the defendant walk away and pull down his pants and expose his buttocks and genitals at the train station. The defendant was also arrested in May of this year for public indecency on the Georgia State University campus. He was convicted in May of this year. He spent 47 days in jail on that incident. And I think he's only been in jail 22 days at this point. The Georgia State incident in May happened in front of a college student, him exposing himself to her. And now only a couple of months later, he has a new charge here where he's actually touching someone. So his behavior is escalating at this point. He is a danger to the community. He has several simple battery convictions between 2017 and 2019, about 4 simple battery and battery family violence convictions. And he was criminally trespassed from MARTA in April of this year. So due to his history, due to his behavior escalating, the state feels like that his recommendation is reasonable at this time, Your Honor.
Let's see. Good morning, Ms. Harrison. Can I get his complete history, please?
Yes, Judge. I have 28 cycles with history in Georgia and Florida. Last arrest was September of this year for simple battery in Fulton County. Record indicates an open probation for loitering, prowling, and public indecency under 22 CR 002855G. Sentenced June of this year, 12 months probation. Also, there is an open case, 22 CP 206588 for obstruction of law enforcement officers by use of threats or violence, obstruction, counts, and criminal trespass.
So he has an open simple battery and an open obstruction, both in
Fulton County. Yes, Judge.
Okay, thank you. I appreciate it, Ms. Harrison. Ms. Helen, given what the state is asking, why wouldn't you want to try to resolve all these cases together?
Well, Judge, he's out for the other cases. Today, we wanted to resolve this one in a plea judge with the probation. Are you asking if you want to move all of these cases together on the calendar?
But no, I'm just wondering, would it be more efficient since, he may get 12 months to serve on this matter alone? That I don't understand why you want to try to resolve the simple battery and the obstruction along with these 2 charges at the same time.
And Judge, we can do that. If
Yeah,
that'll be
I think that might be more efficient and it might be more beneficial to him.
understood, Judge. So can we reset it for next week to add those?
Ms. Salette, do you have any objection to that?
I think that there may be some confusion with the open cases. I see an obstruction case, but it's a felony obstruction case. And then I don't see, was a case number said for the simple battery case?
It was felony.
Oh, they're both felonies? Ms.
He's
Harrison?
on probation on one and the other is an open case felony.
Okay, all
Then
right.
we won't need to reset it. Okay. Then we
All
can.
right. Thank you. Go ahead, Ms. Helen.
Yes, Judge, this is a non-negotiated plea. So far, Mr. Manning has been incarcerated for 22 days. The bond right now is a $5,000 surety. He's not able to afford that bond, Judge. He's the only person helping bond himself out, and he's not able to afford that. He was booked on September the 27th of 2022, Judge. We are asking for time served, that the 22 days be time enough. We understand the psychosexual evaluation as well as the stay away from MARTA, Judge. But we are just asking for that to be time served with the stated conditions.
And Ms. Salette, given that you want these 2 charges to run consecutive, I take it that you want him to be on monitored probation for the entire 12 months that he'll have remaining.
I'm kind of confused with what you're asking, Judge. I'm sorry.
Yes, that's correct, Your Honor.
Okay. All right, thank you. Mr. Walker, good morning.
Good morning.
And Your Honor, I'm sorry, I failed to also add no contact with the victim, Ashley Gresham. Requesting that as well.
Understood, Judge.
All right, so, Mr. Manning, it's my understanding that in case 22 CR 006563G, you wish to plead guilty to sexual battery and public indecency. Is that correct?
Yes, Lord.
Are you under the influence of any drugs or alcohol this morning?
I am not.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, Lord.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, Lord.
Has anyone forced or coerced you to plead guilty?
No, Your Honor.
I will accept the your plea, Mr. Manning. The sentence for the sexual battery is going to be 12 months to serve 180 days, credit for time served 22 days, balance probated. There is to be a psychosexual evaluation and treatment. If necessary, stay away from the 435 West Peachtree Street, MARTA station, or abide by all MARTA imposed restrictions. No further contact with Ashley Gresham. And for the public indecency, it's going to be 12 months to serve. 12 months probation to run consecutive with count one. I am going to waive your probation fees while you're on probation to help you get and stay on your feet, but you're going to have to be on probation for the entire time, okay?
Yes, Your Honor.
Are there any questions?
Yes, Judge, can you just repeat the sentence one more time with the stated recommendation?
12 months to serve 180 days, credit for time served 22 days with the other restrictions. Okay, any further questions, Ms. Helen or Ms. Salette?
Nothing from the state, Your Honor.
All right, good luck to you, Mr. Manning.
Well, Judge, I just want to make sure I get the additional jail time correct for Mr. Manning, correct? Because with that recommendation of, you say 108 or 180?
180, that's half the time that Ms. Salette was asking, correct? 300, she wanted.
So that'd be 68 additional days. I just wanted to make sure Mr. Manning is understanding that and he accepts that.
Well, he's already been pronounced, so whether he accepts it or not, that's the sentence.
Understood, Judge. Mr. Manning, I'll give you a call, okay?
Okay.
All right. Good luck to you, Mr. Manning.
Yeah, may I approach?
Yes.
Okay, here's the situation. Here's his phone number, and I can text him the meeting ID and the passcode. But I've asked him to text me the email so he could just link on, but he could get in either way. So I'm in touch with him by text right now.
Okay. So what do you need for us to do with this? I mean, there's nothing we can do with this, right? You have to contact him, Mr. McLean.
I just need the meeting. See, I don't have the actual meeting ID number.
Oh, so you need someone to send him?
Right. I can text it to him if he will text me back his email right now. I can just send him a link.
So why don't you do this? Why don't you put, when he texts you back his email, put it in the chat, and I'll have Ms. Lewis send him out the information.
Okay, that keyboard works into the chat, or I'll just hand it to the.
Okay, yeah, that'll be fine. Okay, thank you.
Thank you.
Yeah. Well, shouldn't he already have the information and even?
Well, he should. So I've just texted him, and he may just link on all of a sudden.
Right, I would imagine that if he knows to be on at 11 o'clock, that he should have the information to get on it.
Right. What I was going to talk to the state about, Your Honor, was simply that he said to me, I thought I didn't need to go to the meeting now because I just bonded out again the second time. I paid a new bond and got out again. So do I really need to be there, or does that solve the problem? And I said, I don't know. I haven't done one of this particular type of hearings before, and I'll find out what the issue is, because I know what the issues are with regard to the apartment and we're being left off the address.
Okay, all right, thank you. Who do we have next?
Position 18, Williams.
And this is also a non-negotiated plea?
Correct, Judge. The only thing that's at issue is the stay away. I wasn't wanted a clarification, is that all MARTA or just the location? Because Mr. Williams does use MARTA for his employment to get back and forth, so I didn't know.
Does MARTA have an active stay away?
And that was going to be my suggestion. Could it just be, he adhere to any active MARTA suspensions if they are any present?
Have any objection to that, Ms. Saletti?
Can I just have one moment to look and see
Of course.
if I can find whether there's a MARTA suspension in place? And Your Honor, it does appear that there is a MARTA suspension in place until January 1st of 2023. And so if our recommendation will coincide with the MARTA suspension.
So that makes
I'm sorry, Your Honor.
it a negotiated plea if that's the case. Is that correct?
That's correct, Judge.
Your Honor.
Okay, very good. Good morning, Mr. Williams. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir. Good morning.
Good morning. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you, sir. Mr. Webb?
Yes, Your Honor. The state's recommendation on the fare evasion charge is 12 months, serve 16 days, credit for time served 16 days, and balance suspended and stay away from MARTA, adhere to the MARTA suspension that ends on January 1st, 2023.
Yes, Your Honor, that is our understanding of the plea. We do stipulate to the factual basis, venue, and ID.
Mr. Williams, it's my understanding that in case 22 CR 006664E, you wish to plead guilty to fare evasion. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
Represented by counsel, are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Williams. And you know you can't go back to MARTA until January 1st of 2023, okay?
Yes, sir. And just to be clear, is that you said that's all MARTA, or is that just
Well, that's all MARTA, because MARTA has an active suspension against you not to use MARTA. So that's all MARTA until that time. So if you go back there, if you get arrested for any reason for being on MARTA, you'll be in violation, okay?
Yes, sir.
All right, you have any other questions?
So when I leave, when I do happen to leave, I will have to call a ride, right?
Or however you wish to, you can have any other transportation that you would like to have, Mr. Williams, aside from MARTA.
Yes, sir.
Okay, we clear?
Yes.
All right, good luck to you, Mr. Williams.
Thank you, Judge.
Judge, I have an announcement, to clarify Mr. McLean's situation. Apparently his client he came in our office on the 11th of October to set aside, to request his bench warrant to be satisfied to have this hearing for today. And apparently he got picked up on the bench warrant on the 13th of October and made a new bond on the case. So there is nothing to set aside at this point. He has made a new bond.
Okay, thank you, Ms. Lewis. You got that, Mr. McLean?
Yes, Your Honor. So this is moved as I thought.
And also, I just want to clarify, Miss Helen, are you asking for a breakout room for 5 South? I don't see them on the.
Yeah, they're no longer on. That's okay. Thank you.
Okay, okay.
All right, thanks, Ms. Lewis.
You're
All right.
welcome.
Judge, this is position probation 1, Martell Reed.
Give me just a moment. And do we have I have it down that, Mr. Bradbury is being represented by a conference attorney, is that right? Do we have some,
That is correct, Judge. Number one is represented by Ms. McLeod.
okay, Ms. McLeod, are you still with us?
She's
I believe she
online.
logged off, Your Honor.
No, she's on here.
She is? Oh, okay. Thank you.
Ms. McLeod?
Yes, I can hear you. So what should I do? Should I wait from the on?
Ms. McLeod?
I don't know if she's on the phone with her client. Let me call her.
Excuse me, Judge, what's the defendant's name for probation?
Rick?
Are they on you?
You said Rick's?
Say it again?
The probation, y'all can do probation right now?
No, this is Mr. Bradbury that we have now. Mr. Reed is the only probation that we have.
Okay, I'm just getting them, I'm calling them now.
Okay, thank you.
Your Honor, I was trying to get a hold of my client on the phone.
Okay, so you need to talk to Mr. Bradbury? We're on position one. Ms. McLeod, are you with me?
Yes, Your Honor, I'm sorry, my microphone was muted. I apologize. And I was also trying to get a hold of Mr. Bradbury on the phone.
Okay, so you need to talk to Mr. Bradbury?
Yes, Your Honor, I have not had an opportunity to discuss the plea offer with him.
Okay, so can we have Ms. McLeod call courtroom 2 and speak with Mr. Bradbury?
He isn't in courtroom 2, Your Honor. I already called. I think they said he was upstairs in 3 North.
I'm sorry.
He's on the mental health floor. He's on 3 North. There's another officer that's walking around.
At the Rover.
Okay.
Over. So once he gets to that floor, I'll let him know that Ms. McLeod needs to speak to Mr. Bradbury. But right now in front of you, we have position number 1 on the probation.
Oh, okay. I'm sorry. That's my my misunderstanding.
Thank you.
And do we have probation on?
Still, we're just trying to find it. Could someone put the defendant's name in the chat? Because I'm not understanding, or the spelling of the name or something.
It's Martel, M-A-R-T-E-L, Reed, R-E-I-D.
Martel Reed.
Yes.
Okay, just so having the managers walked in the office, so she's getting it now.
All right, thank you.
If you already have number 1, Mr. Bradbury.
All right. Do we have a way that Ms. McLeod can contact Mr. Bradbury?
Do a breakout session, I guess.
Okay, all right. So can we put Ms. McLeod, are you with us?
I know she's been having trouble with her mic. I don't know what's going on, Judge.
She's off camera also, it looks like.
I'll call her again.
Okay, Ms. McLeod, we're gonna put you into a breakout room.
Yes, Your Honor.
client,
Mr. Bradbury.
yes. And courtroom 2, is there anyone else we can take while we're waiting for probation to get on the line?
This is our last person, Martel Reed.
Okay.
Attorney Callaway, was you able to get to the South Annex?
Yes, and we're ready to proceed with position 11 whenever the court is ready to hear that matter.
Okay, thank you. So we'll go to the South Annex while we're waiting for probation.
Morning, Your Honor.
Good morning, how are you doing today?
I'm well, and you, sir?
I am as well, thank you. And this is Ms. Jacobs?
Yes.
Okay. Good morning again, Ms. Callaway. What are we gonna do with Ms. Jacobs this morning?
Sorry, Colonel.
What are we doing with Ms. Jacobs this morning?
It's gonna be a negotiated plea.
Okay, very good, thank you. Good morning, Ms. Jacobs. I'm Judge Eric Morrow. Can you hear me okay?
Yes, good morning.
Okay. Can you raise your right hand for me? Do you swear to affirm the testimony you're about to give before the court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can put your hand down, Ms. Jacobs. We're doing this hearing today by video. Do you agree to have your case heard by video?
Yes.
Thank you. Ms. Salette?
Yes, Your Honor. For the battery charge, the state's recommendation is 12 months to serve, 12 days, credit for time served, 12 days, balance probated, an 8-week anger management course, 40 hours community service, and no contact with the victim, Sparkle Perry, Sparkle, Perry, Perry. The state will be null processing the simple battery charge. And we also filed an accusation this morning for an improper backing charge. I see where it's been filed in case manager, but it doesn't look like the charge has been added into the system yet. But on that improper backing charge, the state would be recommending 12 months probation and a restitution amount of $2,734.45 to be paid to Ms. Sparkle Perry, and that probation can run concurrent to the battery charge, Your Honor.
Well, how am I supposed to sentence her on something that hasn't been, have a number yet?
Is this a add-on to, you adding a charge to the current case that you have now? Because I see it in the system, but I just need to know, are you adding this charge or are you creating a whole nother case?
I'm adding the charge, Ms. Lewis,
Okay.
yes.
Okay, I'll go and put it in the system now, Judge.
Thank you so much. Yeah, the accusation was filed this morning. We just, I think it just wasn't added on to this case yet visually.
Because we wasn't aware of it until now. Thank you. Well, we'll get it correct.
Okay, thank you.
Ms. Callaway?
Yes, Your Honor, we'll stipulate to the facts, and we are asking the court to accept the plea as negotiated. She's been in custody now for 12 days, and she can pay she's gainfully employed, so she can pay off the $2,734.45 within the year, as suggested by the state.
All right, she's been in custody for how long?
12 days. There was a bench warrant in this case. She moved it and hadn't received notice and was picked up on a bench warrant.
Okay, so let me make sure that I have this correct. 12 months to serve, 12 days, credit for time served, 12 days, balance probated, 8-week anger management, 40 hours of community service, and no further contact with Ms. Is that correct for the battery?
That's correct, Your Honor.
Yes, Your Honor.
And then the improper backing, is to run, concurrent. It has a fine, is that right?
Yes, Your Honor.
Restitution amount, yes.
Right, restitution amount.
How much again?
Tell me the restitution amount again, Ms. Loretta.
Yes, Your Honor, it is, one moment, $2,734.45.
All right, so we're all in agreement with that, is that correct?
Yes, Your Honor.
All right. Ms. Jacobs, it's my understanding that in case 21 CR 0004128, you wish to plead guilty to battery and improper backing, is that correct?
Yes, sir.
You under the influence of any drugs or alcohol at the present time?
No, sir.
To be represented by counsel, are you satisfied with your counsel's representation?
Yes, sir.
I do understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury.
Yes, sir.
Or force or coerce you to plead guilty?
Can you repeat that?
Has anyone forced or coerced you to plead guilty?
Yes, sir.
They have? No, nobody's forcing you to enter into this plea, are they?
No, sir.
I will accept the plea as negotiated, Ms. Jacobs. I am going to waive the probation fees for you while you're on probation. Is there a request, Ms. Callaway, as far as once the terms are complete, whether it terminated?
Yes, Your Honor, we would ask that the probation be terminated upon completion of all conditions.
Any objection to termination, Ms. Willett?
I'll leave that to the court's discretion, Your Honor.
All right, I'll terminate. So once you get through all the terms, Ms. Jacobs, I'm going to terminate the probation, which means you won't be on probation any longer. Which means that the sooner you get all these done, the sooner you won't have to be on probation. Okay.
Okay.
All right. Good luck to you, Ms. Jacobs.
Thank you. Can I go?
My business, after I see the plea paperwork, may I be excused?
Yes. Have a good day, Ms. Callaway. Thank you.
Make sure she
Thank you, Your Honor.
sit there.
We're ready.
Get that paperwork sent.
Right, she mentioned that. Do we have, has probation gotten on the line yet?
Yes, probation is on the line, sir, Your Honor.
So why don't we go ahead and take the probation case?
Good morning, Your Honor. How you doing?
I'm doing well, Ms. Officer Harris. How are you today?
Fine.
Good, good. Let's see. Good morning, Mr. Reed. This is the probation revocation calendar. We are conducting this by video to help prevent the spread of the virus. Did you have your case heard by video?
Yes, sir.
Thank you, Mr. Reed. Officer Harris.
Yes, Your Honor. Mr. Reed was sentenced to probation on April the 6th, 2022 for 12 months of probation to complete the domestic violence program. Mr. Reed has not, at the time, Mr. Reed has not reported to our office since April. And I also did want to put on the record, Your Honor, that I have been in contact with the victim, Ms. Freeman, on numerous occasions, by email, by phone, by telephone, that she, of many concerns that I don't want to put on the record due to a minor child that was involved. But those concerns of the victim of emailing me and contacting me was my concerns, and that's why a warrant was issued for Mr. Reed as soon as possible. He has exactly 4 months left on probation, and probation recommendation is to revoke his probation.
How much time does he have left, Ms. Harris?
About 4 months, Your Honor.
4 months?
Yes, Your Honor.
Okay.
No, I'm sorry, Your Honor. My apologies. 6 months. I'm sorry about that, Your Honor. 6 months.
6 months. All right.
I believe Ms. Freeman is in the courtroom presently, Judge.
Say it again.
I believe Ms. Freeman.
She's here.
Yes. I'm sorry. Whose case is this?
It's mine, Your Honor.
All right. So I'm with you, Ms. Helen.
So Judge, yes, we're having a probation revocation hearing today for Mr. Reed. But when I went and spoke to him, he understands the last time he did report was April. However, Ms. Freeman was in a major car accident between the months of May, June, and July. He was their only provider and caregiver and worker between him, her, and their 5 kids. So he was pretty much with her at the hospital or kid carrying and bringing them back and forth between school or daycare, Judge. So at that time, Judge, he was also working 3 years car detailing, Judge. He's currently enrolled in the FVIP. Him and Ms. Freeman enrolled in a separate domestic violence program herself. So he has tried, Judge. He's definitely tried. So we are asking this court not to revoke those 6 months, to give Mr. Reed the opportunity for the last 6 months, complete the FVIP he just enrolled in, and then also give him an opportunity to go back to work, because I don't believe Ms. Freeman is working after that major accident. But again, he is their major primary caregiver right now, Judge.
Okay, so so Ms. Freeman is the victim in the case. Is that right?
That's correct, Judge.
Okay, and are Ms. Freeman and Ms. Reed and Mr. Reed to have contact while on probation?
Yes, Judge. I looked up that order. It's no further violent contact.
Okay, all right. And I guess Officer Harris, I'm gonna need I know that you're reticent to say what's been going on, but Ms. Ms. Freeman is in court with me here this morning. Is there something else that I need to know about this as I'm making my decision?
Yes, Judge. Again, he's their main financial caregiver, and that they are still in contact. It's just no further violent contact, Judge. And we're just asking for, the last 6 months of his probation not to be revoked.
I understand that, Ms. Helen. Officer Harris, there were some things that you were reticent to tell the court. Is that something that I need to know?
I think you should know, Your Honor.
Well, then the only way I'm gonna know is if somebody tells me, right?
I'm sorry. Okay, so apparently a phone call that Ms. Freeman actually gave to when she called me, because at the time I actually gave her my number to give me a call just in case. So the concern that actually had me was that Ms. Freeman said that Mr. Reed stabbed his daughter to the wall and to get to her, and that was really concerning to me, because even though the case does not have to do with their minor child, there's still some kind of violence between her and the defendant, and definitely their minor child.
Okay, thank you. Ms. Freeman, do you want to speak to me?
Today in particular.
Okay, I understand that you are you're having some difficulties with your movement. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. What would you like to tell me?
Today in particular, I don't care if you talk about narcotics, but I have to get out of a world with narcotics. Today in particular, this is referring to Martell's mom will come to the house and give us a ride where I can go get my medicines and things like that. That day he wasn't moving fast enough. If you stop taking the medicines for a while, they throw you into withdrawals. The day on returns, I had snatched my mother's keys and went out the door, and I was going to take off into the car. So he chased after me to get his mother's keys, and in the process, knocked my child down. He wasn't trying to knock my child down. He was trying to stop me from taking her keys, but just like I was trying to tell him, I've been on these narcotics for 2 years. If I withdraw, I get sick. I start throwing up. They make you want to go to the emergency room. Since Martell has been incarcerated, I still have my prescription. I've actually gotten off of the narcotics, and I now take non-narcotics to where I can actually get around, because it was the narcotics. I've never been on pills ever in my life. And this red.
So what you're telling me, Ms. Freeman, is that you're not afraid of
No, I'm not afraid of him. He's the only person I got between him and his mother. I don't have family.
Okay,
His mother is the only reason that we're able to get around. She's the reason that I was able to get here today. So at the end of the day, without him and his mom, I can't roll.
so, Mr. Reed,
Yes, sir.
Ms. Helen also. You say that he's enrolled in the DVID, that you have proof that he's enrolled?
I don't, he's incarcerated right now, Judge. I don't know if he has that paperwork with him or if,
Okay, so this is what I'm gonna do, based on the representation that he is enrolled. I am going to continue him on probation for now. But if that is not the truth, okay, then if he can't provide any proof to this court to substantiate what you're telling me, because I'm gonna be continuing him on probation because I've been told that I'd rather him get some type of treatment than not do anything. I'd rather give him the opportunity to enroll for us, as long as he can be in this class for the next 6 months or however much longer he's on probation. But it's gonna be very tight. Officer Harris, if he does not get you this proof of enrollment in DVID in the next let's say week, then you're to bring him, we're gonna revisit this. If he fails to miss one appointment with probation, we're gonna revisit this. Because I'm not gonna get down the line, another 4 months and have him back here. So let me make this very clear to you, Mr. Reed. You're gonna take those DVIP classes. You're gonna get the information to Officer Harris that you're already enrolled in those classes. You're gonna go to a meeting with probation at every scheduled meeting. And if you don't, you're gonna be right back here where we are today. And if you do come back here, at that point, I'm gonna revoke whatever time you have. So I'm gonna give you the opportunity, but but don't disappoint, okay?
Yes, sir, understandable.
Okay, are we clear, Ms. Helen?
we are clear. And I have a note from Ms. Freeman. She has proof of both enrollment for both classes, her and him. But again, Judge, I'll have her give that information to Ms. Harris as soon as possible.
Okay. Any questions, Officer Harris?
Your Honor.
All right, so.
Your Honor.
Get it again?
Are you in G33?
Yes. So if you'll get me that paperwork, and if you don't get it to me today, I'll get it tomorrow also.
Yes, Your Honor. No, that concludes my business. May I be excused, Your Honor?
Yes, have a good day. Good luck to you, Mr. Reed.
Thank you, Judge.
Good luck to you all also, okay?
All right, going back to number one, Mr. Bradbury.
Judge, we're completed here in courtroom 2. Can you be excused?
Yes, I'll see you this afternoon, maybe.
Okay, see you later, Judge. Thank you.
All right, Ms. McLeod, what are we gonna do with Mr. Bradbury?
He's going to be taking a play, Your Honor.
All right. Mr. Bradbury, I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video? Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Judge.
All right, thank you. Ms. King?
Yes, Your Honor. The negotiated terms are 12 months to serve 72 days, credit for time served 36 days with the balance suspended, a stay away, no further contact, and no drugs, alcohol, or weapons. The stay away address is 1135 Oakland Drive, and that is 2 words, Southwest. And the no further contact is with Willie Hughey, W-I-L-L-I-E, last name H-U-G-H-E-Y.
Yes, Your Honor, those are the terms as we understand them, Your Honor. I would ask the court, my client tells me that he still has some belongings at the location, and we would ask if he could just have a one-time law enforcement escort to go back to retrieve his belongings.
course, Ms. McLeod, we'll give him that opportunity.
Thank you, Your Honor.
Mr. Bradbury, it's my understanding that in case 22 CR 0062226A, you wish to plead guilty to criminal trespass and damage to property, is that correct?
Yes, Judge.
You want the influence of any drugs or alcohol this morning?
No, Judge.
You be represented by counsel. Are you satisfied with the representation?
Yes, Judge.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, Judge.
Has anybody forced you to plead guilty?
No, Judge.
I'll accept the plea as negotiated, Mr. Bradbury. You can go back to that location on one occasion with law enforcement to retrieve any belongings that you have there, okay?
Thank you, Judge.
You have a good day, Mr. Bradbury.
Happy holidays.
Thank you, Your Honor. And Your Honor, that does conclude my business for today. May I be excused?
Definitely.
Thank you.
It appears that that completes the 9 o'clock calendar.
No, Your Honor.
No, we have another one?
Yes, we have two more ladies here at the South Annex. Gosh, I forgot all about Milton.
That's correct, Judge, position 14.
Ms. Powell, please come up and have a seat.
And this is going to be an arraignment and a bond hearing.
That's correct, Judge.
Good morning, Ms. Powell. I'm Judge Eric Morrow. This is a state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Put your hand down. Thank you. Ms. Powell, you've been charged in case 22 CR 0067688C with theft by shoplifting. This charge carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Ms. Helen?
I do, Judge.
How do you plead, Ms. Powell? Guilty or not guilty?
Not guilty.
So record your not guilty plea. Your case will be returned to the division judge and give it notification of your next hearing date. Do we have the bond? No, so this is a new case. Okay, we don't have the bonds on this. Do we know what the bond is, Ms. Helen?
I thought it was a $1,000 surety bond, Judge.
Okay. Ms. Helen, go ahead.
So, Judge, we're having a bond hearing for Ms. Powell today. I'm asking for a bond modification to a signature bond in the same amount. When I went and spoke to Ms. Powell, this case occurred when she was quite unstable at the Wayfield Foods. So there were some items that were alleged to have been taken. And so, Judge, I've gotten some more stable information, address, a phone number, some family who's here in Georgia with Ms. Powell. Ms. Powell is also 36 years old. She's not from Georgia, but she's been here for the last 3 years. So she's definitely a resident. She does have 5 children, one 19-year-old, a 15-year-old, a 14-year-old, a 10 and an 8-year-old. And so, Judge, we're asking for this signature bond. Again, I believe Ms. Powell is going to make all of her court dates. I believe she understands how serious this case is. I don't believe she's a danger to the community. And again, once I've explained to her how serious these theft by shopliftings can get, I don't believe that there's going to be any more rearrest or reoffending, Judge. She has worked prior to this arrest at Publix in the food services department for several months, Judge. So she is employable. So I'd ask for that bond modification today to a signature bond.
Ms. Lett?
And Your Honor, the state would ask that you keep the current bond amount in place. She does have 3 prior theft by shoplifting convictions, 1 in 2019, 2 in 2021, and a 2020 theft by shoplifting arrest. It also appears that when she was arrested for this case at hand, that they also noticed that she had a warrant out of Henry County for theft by shoplifting as well. So there's been a series of theft by shopliftings in a matter of a year, it looks like. She's poses a risk of reoffending again. And so the state would argue that this bond is reasonable, the $1,000 surety bond, Your Honor.
And sorry to cut in, Judge, because Mr. LeMay had mentioned it, but I also see that she has an open felony shoplifting case, 22 SC 183628, that she's also being held on.
May I,
Ms. Powell, you have a right to remain silent. Anything you say can be used against you. If you need to speak with Ms. Helen, I'm happy to give you that opportunity. Sometimes people think that what they say may be of help to them, and in actuality, it's not. So, Ms. Helen?
Yes, Ms. Powell, if you have any questions about procedure or you feel like we need to take a call, let me know and I can give you a call real quick, okay?
no, we can go ahead. That's fine.
All right, what's the bond on the other case, Ms. Helen? Do you know?
I do not.
All right,
It's 3,000, Your Honor.
3,000 good?
Yes, Your Honor.
All right, so,
Judge, that was a bond surrender by the bonding company. They surrendered her on her felony charges.
Oh, apologies. So essentially, that's a no bond, correct?
It's a bond still, and the bonding company is just no longer responsible for it. They surrendered the bond.
Ms. Helen, if she clears that up, I'm certain you can certainly bring her back. So I think that she needs to clear the felony issue up first. And if she has
It's still a $3,000 bond, Judge, for the felony. It's just a surrender. She's no longer on a good bond no more at that case.
But basically what you're saying though is that this $1,000 bond for this case is not what's holding her. It's not what's really holding her. She's still gonna have to deal with the.
Both of them are holding her now. She has to make a total of $4,000 now.
That's what my understanding was as well, Judge.
So I'm not understanding. So she'll be released on the felony? So this is the only thing holding her?
No, Your Honor, she's being held on both. 1,000 on the misdemeanor, 3,000 on the felony. So in total, it will be 4,000.
Correct, Judge.
All right, so if she's not, so what I'm saying is, Helen, is if she clears up the felony, then I'm happy to look at this again. But until she clears up the felony, I'm gonna leave the bond where it is. But if she does clear up the felony, you certainly can come back and I will revisit the ruling, okay?
I understand. Ms. Powell, I still have that tickler for you, okay?
Okay, thank you.
All right, who do we have next?
Next, we have position number 7, Ms. Palmer. Ms. Palmer, have a seat up here, please.
Right, Your Honor, that's simply a not guilty. It's not holding her in jail. This was filed as an accusation last week.
So we need to do a arraignment.
That would be fine. We would waive the formal reading, and I've told her just simply to whatever is holding her in court, that she should speak with the lawyer that is going to represent her on whatever is holding her in jail, and that it should be coordinated and taken into account. It would be foolish for her to do anything today other than simply maintain her silence and be not guilty.
Good morning, Ms. Farmer. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir. Good morning.
Will you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Put your hand down, ma'am. Ms. Farmer, you've been charged in case 22 CR 006765C with battery. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. That's my understanding that Mr. McLean has waived formal reading of the accusation. Is that correct, Mr. McLean?
Correct.
How do you plead to this charge, Ms. Farmer? Guilty or not guilty?
Not guilty.
Reported not guilty plea, your case will be returned to your division judge and you'll get notification of the next hearing. Okay? Good luck to you, Ms. Farmer.
Okay, thank you.
All right.
Bye, everybody. See y'all this afternoon.
This afternoon.
See
Thank
ya.
you.
Thanks for not forgetting about me, Your Honor.
Okay, you're not gonna let me live that down, are you? Officer Milton? One time, it happened one time in 3 years. I'll see you.
See you later. Bye.
Judge Morrow, position number 15, I just emailed a transfer order to the DA's office to Miss Lewis.
Okay,
For that one, and I also emailed a NAPROS order for one of the pleas that we took.
I have both of those, Ms. Select, and I'm signing those as we speak.
Thank you, Your Honor.
And when Ms. Grace is ready, we'll go with them.
Position number 1 was a plea. Position number 2 was reset, defendant release. Position 3 and 4, reset 1025 SAP. Position 5 was a plea. Position 6, reset 1025 SAP. Position 7, reset jail jury. Position 8 was a plea. Position 9 and 10, reset 1025 SAP. Position 11 and 12 were pleas. Position 13, reset jail jury, arraigned. Position 14, reset jail jury, arraigned. Position 15, transferring to the Superior Court. Position 16 and 17, reset November the 3rd competency calendar. Position 18 was a plea.
Any questions, concerns?
No, Judge.
Well, I appreciate it.
Bye.
See you all, next week.
Okay.
All right, have a good day.
Take care, Your Honor.
You too.